Yes, Your Honor. I will just
Can you
start
go
recording
and read the
and
segment? Yeah, please.
this hearing is the matter of case number CFI 030-2022 before His Excellency Justice Ali Madhani. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by ARAA Group Advocates and Legal Consultants. Lead counsel is Mr. Tom Montagu Smith QC. The first defendant is not present. The second defendant is represented by Galadari Advocates and Legal Consultants. Lead counsel is Mr. Sergish Delivka. Thank you.
Good morning, Your Excellency. As you've heard, I appear on behalf of the claimant. You know what this claim is about. Mr. Delevka is here for the second defendant. We don't have the first defendant, but he has filed a written statement. It's 4 pages long. I don't know whether you've seen it.
I have seen it. I have
I'm
read
grateful.
it. Yeah.
Excellent. You may also have seen that the second defendant filed quite late last night a revised version of their submissions. I don't know whether you've seen that.
Yeah, I've seen it, but I to be honest, it was emailed to me. I thought first of all it's the same document. I did not. I was not alerted like this document
Yes.
would have some changes.
There are 1 or 2 changes. And what I'll try and do when I go through my submissions very briefly is just pick out the changes and explain to you what they say. And no doubt Mr. Delevka can deal with them in due course. But Your Excellency, essentially you have full written argument from me. We're very grateful that you've scheduled this hearing. I'm not going to labour this. I'm not going to take longer than I have to. The main aim from my side is to ensure that you understand my position and that I've answered any questions that you have in relation to it. So what I was going to do was give you an overview, and perhaps by reference to my skeleton argument, if you have that, just take you through the stages, and I'll try and be no more than 20 minutes on this so that we can all let you get on with your Friday. So before you today, there are essentially 2 issues. The first is there a right to apply to set aside, as opposed to having to go down the appeal route? And then the second is, if there is a right to apply to set aside, should you stay the proceedings? Should you maintain the order that was made by Justice Maha? On the first issue then, effectively what we say, and there isn't really any dispute as far as I see on this, the rules of this court effectively replicate the rules of the English courts. And the way that those rules have been read in England is that unless a party consents to a hearing being determined on paper, to an application being determined on paper, then the party has a right to apply to set aside. And the reason for that is because under the rules, the order counts as an order made on the court's own initiative. That's what the rules themselves say in RDC 23. Now, none of the defendants actually address these submissions at all, and instead they go into other issues really. And I say, unfortunately, they address those issues such as, did the claimant have an proper opportunity to make submissions? Those are addressed in a way which is, I'm afraid, misleading, and I've pointed out those ways in my submissions. But the key issue, we say, is did the claimant consent to a paper determination of this application? On that, the closest that the defendants get is something that Mr. Manes, the first defendant, says in one of his witness statements. And essentially, and we can go to it if you like, but I've recorded it in the skeleton argument. It's at page 110 of the bundle if you want to go there, but I can just tell you what he says. It's in his first witness statement. He says, in paragraph 17, he says the claimant failed to give good reasons for why there should be an oral hearing. He then says, therefore, the claimant, and this is a quote, gave the court the green light to decide the matter on the papers. And then he says, paragraph 17.4, the claimant's submissions could be interpreted as the claimant giving consent for the JJC application to be heard on the papers, the stay application. So he seems to be saying that the claimant consented. If that is what he is saying, that is straightforwardly false. It is not true at all, just as a matter of fact. And what I was going to do is just take you through in the skeleton argument, because that's the quickest way to do it, what we actually said.
What,
If you've
Mr.
got,
Mr. Montek Smith, what,
yeah.
do you think the claimant, sorry, D1 did mention that? So what he means exactly is the claimant conduct towards the application hearing warrants an agreement that it should be dealt on paper or a waiver or whatever.
Well, I can show you what he does say. What actually? Let's go to it then. It's at bundle tab D.
Yep. 1 second.
And page 100. And 10, sorry, 110.
This is the witness statement, isn't it?
Yeah, this is Mr. Mannis's third witness statement.
Yeah. What paragraph? What paragraph?
So paragraph 17(1). So he starts the claim on the previous page 109 under the heading the claimant's application to set aside the stay order, and then he says paragraphs 7 to 18 say predominantly contain legal submissions, and says I'll leave it to my legal advisors. Paragraph 17, the only observations that I would make are as follows, and then this is where he makes the case. So he says, by its 16th of June 2022 submissions, the claimant emphatically contended that the position regarding the JJC stay applications was clear and simple. A stay should not be granted by reason of the claimant's interpretation of a recent DIFC Court of Appeal judgment. That's a reference to Lacan. Having made this statement, the claimant failed to provide the court with any good reasons as to why the matter needed to be heard at an oral hearing, or even required additional legal submissions. And then 2, he says, I disagree on the law. However, putting that to one side, and then he says this, having given the court the green light to decide the matter on the papers, it's obvious that the claimant now seeks to complain about the court proceedings on this basis is only because the order was adverse to it. So in other words, he says, given the green light because of the failure, it seems, to provide good reasons for an oral hearing. That's not the test. The test is whether we consented. Did we say, yes, we're happy to have a paper determination? But he says the green light, which is a misleading statement, because a green light means go ahead. It means consent. But we didn't do that. And then 17(4), in the circumstances where the claimant's submissions of the 16th of June 2022 can very easily be read as providing implied consent for the JJC applications to be heard on the papers, I believe that the proper course, and so on. And so you have to look at the 16th of June submissions. And I was going to do this by reference to the skeleton argument and take you then to those submissions. Believe. Well, firstly, we have to go to D74.
D74?
Yeah, it's page 74 of the bundle. So this is a passage from Mr. Stottard's first witness statement. Starts on page 72. It's the 25th of May. And you will see, for example, paragraph 10 on page D74. In relation to the stay application, Ms. Ziller has requested that this be dealt with on the papers. The claimant maintains that both applications should be subject to a live hearing. If the court decides that the stay application should be heard on the papers, then only then the claimant will seek a direction that it be entitled to make written submissions in relation to that application. And you get that position maintained consistently. So if we go down to page 95, you'll see Mr. Stottard's second witness statement. And again, he makes effectively the same statement at paragraph 9. And I'm
Mr.
afraid I've been
Stockhart
given.
is your witness, isn't it, Mr. Montague?
Yeah, so the point that I'm making is that the question is, did my client consent? My witness says we want a hearing. It doesn't say anything about consent. I've been given the wrong reference, unfortunately, for the next bit, but I can take you to it. That's why I was struggling a little bit. The consolidation submissions, which are the 16th of June submissions, are at page 1. It's at the beginning of tab 7, so it's page 1165.
What's the reference again, Mr. Muslim?
It's tab 7 of the bundle, page 1165.
Yes, the first page, yes.
Yeah, so these are the submissions that Mr. Mann said can be read as giving consent to a paper determination. You'll see these are the claimant submissions in respect of consolidation. You'll recall that the court ordered that on the 10th of June. On the 16th of June, these were exchanged. And then if you go down to page 11, well, it's paragraph 8. You see under the heading request for oral hearing.
Right, yeah.
The claimant respectfully requests an oral hearing to determine the stay applications. The claimant's position is that it's simple, mere fact, and so on, refers to Lacan, and then says the threshold has not been met. This will be the subject matter of further legal submissions in due course. Claimant submits, paragraph 9, that an oral hearing is necessary because the importance of the issue at stake, and then so on, and explains why that is the position. So Mr. Mannis is saying, well, you can read that as somehow giving consent to a paper determination, and that's simply not true. There's nothing in there that one could possibly interpret as giving consent. And I don't think, in fairness to Mr. Delevka, that he says that the claimant did consent. It obviously didn't. So you'll recall what happened after this. The only things that happened after this, the court had ordered submissions on consolidation and had indicated it was going to give a direction as to whether there would be a paper determination or not. The only thing that happened after this was that the judge issued the consolidation order. The claimant asked the registry, is this going to be decided on paper? And the registry came back, said it's going to be decided on paper. And then the next day at 8:48 a.m., we received the order itself. So that's all that happened between these submissions and the order coming in. So there's no possible argument there, it seems to me, that consent has been given. Now, the English, according to the English authorities, the effect of the rules is that's the only issue. That's the only question. Did we consent? If not, then we're entitled to apply to set aside. Now, there has been an argument in a previous case, but never determined in this court, that the position is a bit different in this court, and the position might be different if the parties have actually provided the court with written argument and had an opportunity to argue out in full on the papers. Somebody has argued in the past. Well, then that's different here, and when that's happened, you can't apply to set aside. And it kind of comes down to the question of the interpretation of Rule 412 and Rule 413, because 412 says the court may make an order of its own initiative without hearing.
When you say the parties, I mean, being given for right to argue it, do you mean you refer to skeleton argument, for example, or it's
no,
because you already have a submission, but
yeah, but
your submission was to consolidation of the claim instead of.
Yeah. Exactly.
But you have touched upon the merit of the application. That is, you see what you've been saying in paragraph 10, or sorry, 8 of your submission. You have, I mean, you're touching upon the merit of the application, Mr. Munchsmith.
Yeah, we gave the outline, but we didn't make legal submissions. We said, well, this is the primary case that we'll rely on. But there are, when I get to the JJC application itself, there are 2 points. The first point is, has anything happened in either court which could amount to a conflict of jurisdiction? And that's the Lacan point. And then the second point is, put that aside, are those conflicting cases at all, even if something could have happened? So we made a very broad gesture towards the point that we were going to make on the first, but we nothing in that could be construed as being full legal submissions, a full opportunity to make legal submissions. The rules provide for what should happen if there's going to be a paper determination and the court says I'm going to give the parties an opportunity to make submissions. It's rule 4.10, and the rule says where the court proposes to make an order of its own initiative, and again that's where we are because of the way this happened. 1, it may give any person likely to be affected by the order an opportunity to make representations, right? That's rule 4.10(1). And 2, where it does so, it must specify the time by and the manner in which the representations must be made. Does Your Excellency have that? So
Yes.
that is how the court gives the parties an opportunity to make representations on an application on the papers. So has that happened, and why is that necessary? The point is that if that isn't done, otherwise you're just going to get legal submissions all the time. You're going to get endless legal submissions from the parties. And that's effectively what Mr. Delevka says we should have done, although he later says we shouldn't do it. But effectively he says, oh, well, there was time. Of course there was time, but disciplined parties before this court don't just simply lob legal submissions at the judges and say, oh, well, this is what I'm saying. And because what you end up there is rather like we've got here, iterative, so endless back and forth. So the way it works is the court has to decide for itself, am I going to decide this on the papers or at a hearing? If at a hearing, obviously, then you have skeleton arguments and then you have oral submission, and then it's obvious. You don't need to make any further directions because there are default directions in the rules.
But Mr. Smith, if you allow me, to interrupt.
Of course.
Well, I have, one difficulties, is that, now you're referring to the section of the court power to make order of its own initiative, isn't it?
Yes.
And what it's troubling me now is when we refer to this section of its own initiative, what's first come to my mind is that, the court need to decide something that not based in parties brought or developed application where fees paid, application and served and the other parties. You know what I mean?
I do, and there's a reason. The answer to that. Sorry, I'm going too fast, and I've skipped that stage. It is in the skeleton argument, but if Your Excellency goes forward to Rule 2369, it's the effect of the rules. It's the combination of 23.
I think 23 make reflect in 4, isn't it?
I'm sorry.
23 make reference to the part 4 as well, yeah?
Yeah.
He said 2329, isn't it?
2369.
69.
So you see, the first rule is this: the court may deal with an application without a hearing if 1, the parties agree on the order. 2, the parties agree that the court should dispose of the application without a hearing. So that's the consent to a paper determination. Or 3, the court does not consider that a hearing would be appropriate. That's 2369(3). If Your Excellency then goes over the page to Rule 2378, where Rule 2369(3) applies, the court will treat the application as if it were proposing to make an order of its own initiative. So that's how it works. So that's why. So and I've taken this a little bit too fast. Those rules are the ones that you find in the CPR in England, and those are the rules that have been interpreted in the cases that I've referred to in my skeleton. So that's how you get to of its own initiative. I agree that otherwise it wouldn't be of its own initiative, because as you say, it's an application made by one of the parties considered by the court. But the point is that the effect of these rules is that if the court says against the interests of a party, I'm going to decide this on paper, then it counts as an order made on the court's own initiative. And that's why we get into all of that. Set part 4.
And you saying in this application, Justice Maha is the one who decided that hearing is not inappropriate. It's not.
Yeah,
There is no party's consent, so that is the reflection, isn't it?
It's not my party's consent. Certainly, that was the position of the defendants. They wanted it on paper. My client didn't consent. The result is that we're not in 1, we're not in 2, we're in 3, and therefore 2378 applies, and therefore it's treated as an order of its own initiative. And the logic behind it has been explained by the Court of Appeal in England. And in England, the logic is, well, A, that's what the rules say, but the reason why the rules say that is because in our system, we always give people a chance orally to explain themselves, because something can get missed otherwise. And so that's why the answer is simply, is it consent, is it not consent? If it is, if there's no consent, it's an application to set aside and not an appeal. As I say, there was this argument, it was never determined, and it may have been before Your Excellency, it was a case that I was involved in, where a party said, oh, well, it's different in the DIFC court. It's not just about consent, it's also about whether there's been legal argument. That's, we say, not what the rules say. It's not what the English courts say. Consent is the issue. But my point was simply that even if there was this further question, was there an opportunity to make legal submissions? In this case, it's very clear again, there was no opportunity given to make legal submissions, because that opportunity has to be given in directions.
So you're saying it's about the right of representation and making legal submissions?
Well, I mean, my first point, my primary position is it's about consent. It's about consent to a paper determination. And if parties don't consent to a paper determination, the effect of the rules is, as the English courts have said they are, which is you get an application, you get a chance to apply to set it aside.
Yes, it's a full review of the application, isn't it?
It's a complete rehearing of the application, exactly. Yeah. So the bottom line here is that because we didn't consent to a paper determination, you just have another opportunity, and you hear it again. But even if it was suggested that, well, that doesn't apply if parties have had a chance to make representations, we haven't had a chance to make representations. We made very clear, in fact, the first defendant did this too, when represented, said, well, look, it's okay to have a paper determination because everyone will have a chance subsequently to make legal representations. But that never happened because of the way the decision came through. But that's a bit of a red herring. It's a bit of an irrelevance, because the issue really is just consent. So that's it. That's the application to set aside. What else is there? There's a bit of focus in Mr. Delevka's submissions about things like, were there any reasons and all that sort of thing. I mean, we say that the submissions on that are just obviously wrong, but in any event, they're irrelevant, because the question about reasons goes to appeals. If a judgment is wholly unreasoned, that may in itself be a ground for appeal, but it's not an issue for you today. So all of that is irrelevant. The only question is consent, we say. So that's the set aside aspect, the first issue. What about stay? So Your Excellency knows that the applications are based on Decree 19. And what we say, these are sort of standard, well, what was standard before Lacan, standard blocking applications. So they're just directed at delay, and they're directed at preventing this claim from continuing. And for the last 4 months, they've been quite successful in doing that, unfortunately. But that is totally contrary to the Court of Appeal's decision in Lacan. So what we say about JJC application is that there are 2 problems for the defendants. The first is the Lacan problem. Nothing has happened in either court which could amount to a dispute for the purposes of Decree 19. So what's required there is a positive decision in each court on jurisdiction. Nothing has happened of that nature yet. And nothing will happen in relation to the second defendant because she hasn't made an application disputing the jurisdiction, and it's now too late to do so. So she has, by application of the rules, she has submitted. That's so. But anyway, the key point for you today is nothing has happened, and the second point is that there's no conflict between the two proceedings in any event. So even if something had happened. And I just emphasize on that, and I'll deal with those briefly if I may, but I'll just emphasize first, it may be important for Your Excellency to record both of those reasons in your judgment. Otherwise, this may, as you can anticipate, come back later down the line. So on the first issue, Your Excellency is no doubt familiar with Lacan, having sat on the Court of Appeal in that. I won't go through it in too much detail unless you'd like me to take you to the passages of it. But what I was going to do was just show you the two paragraphs which I've recorded in my skeleton argument. So if you've got that, and turn please to paragraph 54. If you're looking at it in the bundle, it's at page 1211, 1211.
Yes, it's open before me, yes.
So paragraph 54, I repeat the critical passage from Lacan, although the run up to it is important as well. But in paragraph 35, Justice Wayne Martin says, there must be some step in the proceedings amounting to a relevant exercise of jurisdiction by the court, or refusal of the step on jurisdictional grounds, in order that there be maintenance or declining of jurisdiction within the words of the chapeau to Article 4. There must be at least an occasion for deciding to waive or not waive jurisdiction. And then I cite the paragraph from Justice Sir Jeremy Cook's decision, probably the most recent decision, I think, on this issue in the DIFC investments case. There can be no claim or disclaimer of jurisdiction until the court makes a positive decision that it either has or has not jurisdiction over the relevant claim. So nobody says that that has yet happened in either court. And so that is the end of it for the first issue. What on the law though, what Mr. Delefka says is that another case called KBBO somehow assists him in his position. I mean, that was a decision in quite a long-running case, the Emirates MBD case. It was a claim by a consortium of banks under a facilities agreement, a restructuring agreement against Mr. Bin Bouti, or one of the Mr. Bin Boutis, in relation to a group of companies that was struggling in the UAE. And if you have my submissions, again, you'll see what I say about KBBO, paragraph 59, but just to emphasize it, that was a case in which the stay was imposed, but it was imposed before Lacan was decided. That was on the 1st of July, 2020. And everybody accepts that before Lacan, what was happening was that parties were starting proceedings in the Dubai courts, they were issuing a petition in the JJC, and then immediately saying, ha, that's it, we're stayed. And I think the difference, what happened with Lacan was we were in that period where the JJC was taking a very long time to decide things. So over a year in some cases. And so you'd have a stay indefinitely. And so in Lacan, the party said, look, we're not just going to sit and wait. We're actually going to escalate this. They did. And the Court of Appeals said that practice now has to stop. We're not going to do it that way. So when Lacan came out, in KBBO, we went back to the court and we said, please lift the stay, because look, the law has changed. But what happened in that case was that we had a hearing in front of Justice Wayne Martin. This is all in the judgment, and I give you the references in the skeleton. But we had a hearing before Justice Wayne Martin, and then 2 days after the hearing, the Dubai courts determined the jurisdiction application.
Oh, made ruling, yeah.
And they dismissed the claim. So then the judge said, oh, well, actually, all of these arguments about Lacan have become really academic, and he lifted the stay anyway. So Mr. Delefka relies on that case, and he says, oh, well, the only reason the stay was lifted was because the Dubai courts dismissed the case. That is simply not the case. That's simply wrong, and you can see that from the judgment of the case. What happened was, as I say, following Lacan, the application was made, but then it became academic. So, but during the course of that judgment, and you see this at paragraph 66 of it, which I've also referred to, and I can take you to all of this if you'd like me to. But during the course of that judgment, one of the points made by the defendants in that is they said the fact of Lacan, the decision in Lacan, is not a sufficient change to justify another revisiting of this issue. This issue's been decided, it wasn't appealed. You need a change of circumstances to revisit it without an appeal, and the decision in Lacan is not sufficient. And what the judge said was, actually, yes, it is sufficient. Lacan represents a complete change of approach to these issues in this court, and therefore I allow the claimants to make this application. So there's nothing in KBBO that supports the second defendant's position, and to the contrary, it's totally supportive of the position in Lacan. And if it was inconsistent with Lacan, it would be wrong anyway. And you're obviously bound by the Court of Appeal authority. The only other authority I wanted to show you on this was actually a decision by the JJC itself, which again shows the modern approach to these sorts of issues. It's two short passages in a case called SR Projects. I don't know whether you've seen this already, but you can find that it's in bundle section 11, and it's at page 2845. You may have to do a search for it, I'm afraid.
Two 845, you said.
So the decision itself starts at 2836. And the relevant passage that I wanted to show Your Excellency is at 2845 under the heading Decision.
Yeah, I'm waiting for the page to be downloaded. If you just bear with me, Mr. Muslim.
Yeah, thank you. It's a large, I'm afraid it's a large section of the bundle.
I think it is the largest one, yes. What's the reference again? I just
2845.
284. I'm so close. Nearly there.
While you're waiting, I'll just tell you what it's about. So this was a claim to enforce a Singapore judgment in the DIFC courts, and there was a jurisdiction agreement, and the defendant had submitted to the jurisdiction and fought the claim. And then the party, but hadn't paid out on the judgment from Singapore. So the claimant had brought the Singapore judgment to the DIFC courts with a view to enforcing it. And then the Dubai courts, the defendants had brought claim in the Dubai courts seeking to block it and a JJC petition. So that's the question. And it went up to the JJC. And if Your Excellency's got there, it's paragraph 18 is the
Yeah, I've reached 2844 is downloaded, but I'm waiting for the next page.
see. We just need two more pages. It's two, actually three. It's 2845, 2846, and 2847. I wanted to show
It's open, yes. It's open, yes.
Super.
Okay, you
so
said paragraph 18 or 19?
paragraph 18 to start with, and then we'll look at 19. So
yeah,
having given you the background, you'll see there's reference, as you would expect, to the DNB Bank case above, but then the decision at paragraph 18, by the guarantee, the appellant solemnly agreed that the guarantee should be governed by the law of Singapore, and the appellant submitted, and we have to go over the page, I hope that's still there, to the jurisdiction of the courts of Singapore in respect of any proceedings that may be brought at any time on the guarantee. So just thinking about, pausing there, just dealing with the first defendant, there's no jurisdiction agreement, but the first defendant submitted to the English courts because he participated fully. He instructed senior counsel and participated fully in the trial. When sued on the guarantee in the Singapore Supreme Court, the appellant dragged the claim out by insisting on service through diplomatic channels, and at the eventual trial abstained from contending that the guarantee was invalid because Mr. Tapash Bhattarai lacked authority to sign it on the appellant's behalf, as it now seeks to claim in the Dubai court. It can therefore be seen that by bringing its claim in the Dubai court and making this application to the JT, the appellant is cynically and discreditably attempting to escape its undoubted obligations under the Singapore judgment, and is thereby abusing the process of the JT as established in Decree 19 of 2016. And then this is the relevant part. So we say this is on all fours with our case. The application is misconceived because, one, the DIFC court has not yet ruled on the appellant's challenge to its jurisdiction to enforce the Singapore judgment, and therefore it is premature to conclude finally that there is a conflict of jurisdiction between the DIFC court and the Dubai court. Two, on the particular facts of this case, including in particular the appellant's agreement that the guarantee is governed by Singapore law, the appellant's submission to the jurisdiction of the Singapore courts in respect to the guarantee, and the MOU, it cannot be said that the courts of Dubai have general jurisdiction over the parties which take precedence over the jurisdiction of the DIFC court. So that is an example of the JT, the JJC, whatever you want to say, taking the same approach as Lacan and saying you have to have a positive decision on jurisdiction before there can be any conflict. And so, as I say, firstly, nobody says that that is anything that has happened in the Dubai court. Certainly it hasn't happened in this court. In this court, second defendant could never establish a conflict of jurisdiction because she has not made an application disputing the jurisdiction. Now, we saw that the second defendant filed submissions again last night, and one of the things she said, and this is a change from the previous version of her submissions, is she says, oh, for the avoidance of doubt, the second defendant does dispute jurisdiction, is challenging the jurisdiction. He says that at paragraph 60 of his skeleton argument. I'm not sure how my friend feels able to say that, because there is no application that has ever been made to the DIFC court by the second defendant disputing jurisdiction. And the result of that under Rule 12.5 is that she has taken to have submitted to the jurisdiction. So there will never be any dispute of jurisdiction in relation to her. And in relation to the first defendant, he is on all fours with the SR case. It's a cynical and discreditable attempt to block the enforcement of a regular judgment obtained in England. The other new submission that we have, and I better show you this, if you have the second defendant's skeleton argument, is at paragraph 51. It's a slightly bizarre statement. Paragraph 51 of this new skeleton says this: it is respectfully submitted that DIFC courts cannot create binding common law authority interpreting Articles 4 and 5 of the decree, as they are imperative norms of UAE law, not DIFC or English law. And I've got a word written here that this probably goes a bit far, but I mean, the JJC decree is a legal instrument which affects the operation of this court. This court has to interpret it. And just as it has to interpret the judicial authority law, the judicial authority law is a law which is issued by the ruler of Dubai, just as is Decree 19, just as is all of DIFC law. And it's obviously for this court to take a view on it. It affects and it relates to the DIFC. And so it has to, in the system of law that we have in the DIFC, we have to have a system where the court takes a view on that in a consistent way. And the way that we implement that is the Court of Appeal makes the decision on it, and then the first instance the judges have to follow suit. Now, it's not impossible for the Court of Appeal to change its mind about the interpretation, but only the Court of Appeal can do that. And attempts to do that post-Lacan have all been rejected. There's never been permission to take this up again because the court is completely satisfied that it's a recent decision and it's right. So the idea that somehow the DIFC courts aren't entitled to interpret that statute is just nonsense, I'm afraid. And it's interesting because those words are almost word for word what the first defendant said in his brief written submissions before the last hearing. So somebody is feeding the same lines to both the defendants, but it's legally incoherent what's being said. I'm afraid bound, even if I'm not afraid, it's the right decision, but you are bound by the decision in Lacan. So that's the first aspect.
Yeah, what I think, I mean, in this point, I think we do understand that sometimes in some decrees, sometimes in some law, the law would, I would say, would outline what authority is empowered to interpret such law or whatsoever, you know what I mean? And sometimes it's kept open, and what authority is, it said, affected by the law would have an authority to interpret it. But I'm sure Lacan also has relied on some of the JJC decision itself. It's Lacan judgment discussed some, I think 4 or 5 JJC decisions before it's landed in its final position.
Yeah, I mean, but I think you know there are statements in the judicial authority law in Law 4 of 2004 that there are statements which say the DIFC court shall have the authority to interpret DIFC law, and then defines DIFC law as law affecting the DIFC. So on one view, the JJC decree is a DIFC law. On one view, so is the judicial authority law. But that isn't the question for today, because what does that mean? What I'm not asking you to make a decision which affects or imposes an interpretation of the decree on the Dubai courts. I'm asking you to make a decision for your own purposes and say, what does this mean? How do I interpret that? Well, I'm bound by the Court of Appeal decision on that for my purposes, for the purposes of the DIFC court. You have the DIFC Court of Appeal said within the DIFC court, this is how we're going to construe that. So it's not even really a question of who gets to decide what it means between the Dubai courts and the DIFC courts. We're just saying for the purposes of the DIFC, only the DIFC court can decide this. So that's why I said it just doesn't make any sense at all. So there's no conflict of jurisdiction at all. And what you won't find in any of the submissions that have been filed, despite all of the money that has been spent on all of this and all of the time that they've had to put it together, is any explanation of how this is consistent with Lacan. It isn't. And then the second point is that there is no possible conflict between the two sets of proceedings. And to understand that submission, you have to break this claim into two parts. So the first part is a claim to enforce the judgment against the first defendant. That's the English judgment. So that's the main focus of the claim. And then the second part is freezing of the DIFC shares in the second defendant's hands, and then executing on them on the basis that really they belong to the first defendant. So if we deal with it in those two parts, the first part, as I say, is just enforcement in the DIFC of a foreign judgment. That's all that we claim in relation to that against the first defendant. Only the DIFC court can do that. And I deal with this at paragraph 65 of my skeleton argument. I'm not going to go through it in much detail.
No, I see it's before me, yes.
I'm grateful. I mean, the point is that all of this has been looked at by the DIFC courts in the past, in the context of arbitration agreements and awards.
Mr. Smith, if I may ask, I mean, to what extent this court, I mean, hearing the stay application, would look at them, I mean, nature, I don't want to say the merit, the nature of each application, and then I would say there is application before Dubai court. There's application in here, and that's another. So on what stage, whether the courts, have taken any active actions toward any of the case, like is it positive or negative, whether there is any challenge of jurisdiction or clash of jurisdiction have been started yet, and that's something else. But I said, to what extent, this court, when it comes to the subject matter, would go and discuss the nature of each application details, and then to decide whether there could be any sort of conflict. My question, do we have to go that far, or we just gotta stop where the point? Well, it's anyway, at the end of the day, it's for someone else to decide, but the trigger is not yet triggered. You know what I mean?
Yeah, I understand what you're saying. And the answer is you could stop there because there is enough. I agree with that. I think the reason why we would ask you to go on and look at the second part to say, well, even if there was some sort of jurisdiction complaint, these are not two intersecting claims. It is because otherwise you may see us again on this further down the line. And then you will have to decide that, because so if there are two claims between two parties, say there was one in the DIFC court, say under an employment contract, and one in the Dubai courts, which has got nothing to do with it or is related, but is about sort of say the theft of some money or something like that, then those two claims may or may not overlap. But if say they don't, say they've got nothing to do with each other whatsoever, then even if you have a situation where both courts say, yes, I have jurisdiction over the claim, there's still no dispute of jurisdiction because they don't touch on the same subject matter. They're not the same claims. And so that's why there is a real question that would need to be determined once we get to the point in those two claims that both courts have said, yes, we do have jurisdiction over these claims. Because then the DIFC court would have to say, in the face of a JJC petition, well, actually, is there now a dispute within the context of that? So Lacan is dealing with the first element.
Yeah.
Have we got to the right stage yet? But there is a second element, which is what is the content of these claims? Do they actually conflict? Either is sufficient to say that you shouldn't get a stay. And so, yes, you're right. If you agree with me on Lacan, you can just say, well, that's enough. But if you are minded to, and I wasn't going to spend a lot of time on this because I take your point, but if you were minded to, I would go on and look at this second phase and determine.
Well, see, this is the JJC is, relatively very new jurisdiction in here, and the original jurisdiction is the Union Supreme Court. And that's what's the position Union Supreme Court is was taking. It's the court will not involve unless the two courts have finally decided on jurisdiction, and then they would look at it. So they would have a better chance to see. There might be no conflict at all toward the end. You know what I mean?
Yeah, I understand. I understand. I hear what you say.
The conflict is so severe that both courts rejecting the cases.
Yes, quite. And that has happened. That could happen. I can see that.
Well, it could happen. Dubai court. The situation in Dubai. I would agree with you. It's like the involvement is really too early. Maybe that was Lacan tried to introduce. I would say intermediary stage, where it's not too final as the Union Supreme Court, but it's not too early by submitting a claim form. But I said from that basis too, whether it's too early or it's a good stage now for the involvement according to Lacan. That is, do we have the authority to say now whether there could be any conflict, as these two cases are identical? Is it between same parties, same subject matter or not?
Yeah.
Knowing this is for someone else to decide, why should I put my nose into it at this early stage?
There's two questions. One is, can you do it? And the other is, as a matter of discretion, do you need to do it? Is it a good idea? I don't think there's any doubt that you can do it, because you'll have to do it at one point if we get to that stage. So say, as I say, if you take my claim, my argument about my example of two unrelated claims between the same parties, one in DIFC and one in Dubai, Yeah, at some stage, somebody might put down a JJC petition and then apply for a stay. And at that stage, the court has to say, well, have we actually got two claims that conflict here?
Well, I see your point. You said the court
Yeah.
should not be naive and dragged by unrelated cases. So that, as you're saying, the defendant could bring any cases between itself and another party is not even involved, and then they would say,
Yes.
well, because we said this is a case in Dubai court. Well, you see,
Yes.
the court should take an active action and at least give its first sight what it's mean. Is that really going to
Yes.
create a conflict or not? So
Exactly.
I
And
see what you mean.
that's effectively just an extension of what happened in Lacan, because before Lacan, the court said, I'm not going to put my nose into this at all. As soon as there's a JJC petition, I'm going to stand away and let the JJC decide if there's a conflict. But in Lacan, the Court of Appeal said, no, we are now going to look at this and decide for ourselves, is there a conflict? Are the conditions satisfied in the decree? And the condition that Lacan was looking at was not this part of it. It was the part of it that says, have we reached the right stage of those proceedings? But logically, if you're looking at that question at all, you're looking at all aspects of it. And the second part of it comes at that point. Are these actually? So I think the answer is, can you look at it? Yes, you can. You have to look. I mean, you will have to eventually. Should you look at it today? You don't have to. I'm just suggesting that it might be a good idea. Otherwise, look at how much delay has been caused by this one application already in this case. And so if you're with me on the second part of it, and it's a very short point really, then I would urge you to make that decision now. But I'm not going to labour it, and I understand Your Excellency's position. I just wanted to emphasise the sort of practical utility of doing it. You can, I think you should, but I can understand if you don't want to. That's how I would summarise the submission. So I won't go into this in a huge amount of detail, but the point, the critical point is if we break it into those two parts and look at what is the substance of the claim against the first defendant, it's enforcement of an English judgment in the DIFC. And so only the DIFC court can deal with that claim. We're not asking for enforcement of the judgment in Dubai from you. We'll ask for that from the Dubai courts, and we'll ask for that in various different ways if we need to. We may not need to if we can enforce against this restaurant shares and they are of sufficient value. That may be all we need to do. But that is a question for another day. The substance of the claim is enforcement in the DIFC of a DIFC claim. And that's in Maidan, for example, in the context of arbitration agreements. The Court of Appeal was looking at this, and one of the parties said, well, this is not the right court for enforcing an arbitration agreement. And the DIFC Court of Appeal said, what are you talking about? This is the only court that could enforce an arbitration agreement in the DIFC. And they followed on from English authority, which looked at that. So questions of forum non-conveniens and things simply don't arise because you're dealing with enforcement. So
if I understand your case correctly, I think now we are in a situation where this DIFC establishment owned by a new party that not the D1, and it's for you to tackle this obstacles is to bring the Dubai court's decision changing the ownership of the shares under the sham theory. And it's for the voiding of enforcement process. Is that what?
Yeah, that's the second part. So I was breaking it into two because you're dealing with two defendants and there are two separate sorts of claim against them. So the first one, I was dealing with the first defendant, which is just the enforcement of a judgment. There can't be any kind of conflict there. The second one is, as you say, affected potentially by this decree, by this decision. Now, it's a divorce decree, and just I mean, it's presented by the defendants as deciding the ownership of the shares. It doesn't do anything of the sort. So it's simply I'll show you it in the bundle if you like. It's at page 457. But it's in tab 6.
457, you said?
457, yes.
Right, I'm in there, yes.
Thank you. All right, so you see there a degree, sorry, a divorce certificate. And if you read there, you see that they recite a statement from the two parties. It's in the 4th line down. Our marriage union cannot be maintained because of life together has become impossible, and so on. The wife here present validated what had been said. And then in witness thereof, the court decided to terminate their marriage contract, and the wife will thus have to observe her period of waiting as of the date herein. That's the effect of this certificate. It terminates a marriage. That's between the defendants. We're not interested in that. We're not interested in any of that. It has nothing to do with us. And then it says, furthermore, the two parties have submitted a family agreement registered under the number so-and-so. Such agreement has been publicly read upon them and they accepted it. The same has been approved and the present certificate has been issued for all legal intents and purposes. So all that has happened is that they've got divorce. They've reached an agreement between themselves. And that has been rubber stamped by the court. It doesn't say anything about the ownership of the shares in the DIFC company. And not only that, how could a Dubai court have jurisdiction to determine who owns DIFC shares? The only court that can say this is the ownership of the shares is the Court of Incorporation. So it's been suggested that somehow we need to attack this judgment. And unfortunately, in the JJC, the second defendant has misrepresented submissions that I made at the ex parte hearing. They are simply to give the impression that what we're trying to do is attack a Dubai court judgment. The way that
Mr. Montague-Smith,
Yeah.
I think the next letter, like in the page 459 and 460, will suggest the court is writing to the registrar of the companies to move the shares. And even the decision we were reading together, it refers to the family agreement that the court adopted. Maybe this certificate is not the full picture of what's going on, but I think the document before is the one. Let's see, where is it? I'm trying to see because I do see before me and the agreements under the Dubai court logo. It's in details. It's in Arabic. I don't think it is translated. What's it translated is the.
I see. I can only work from
I think,
the English language.
Can you see 457?
457, yes.
Yeah. 457, interpreting the next page is 458. Is that right?
I think so. You'll be better placed than me to do that.
Yeah, it is. So, but however, there is a detailed agreement in the previous pages, which is exactly page 455.
Yeah.
It said the agreement number 86, which referred into the previous page we were talking, and it's giving the agreement between parties in details. Unfortunately, I do not see any translation to it. Might be missed out or something. Oh no, hang on. There is a, yeah, there is. Okay, the interpretation is in page 451. Can you go to page 451?
Yes, I've got that.
Yeah, it's over there, I guess. Yeah.
So that's the application.
Yeah.
Yeah. I think that is to do with the Dubai court's claim, though.
Oh, I see. Okay, no,
I
no.
don't think that's a translation. I think that's the actual Dubai court's claim
No,
itself.
that's the claim. That's the claim.
Yeah. But look, I mean, in a way, it doesn't
But
matter
I
what that
think you
says.
need to give important focus to page 455.
Yeah. So let 455. Understood. All right. Well, we need to look at that. I mean, I think that
Anyway,
the way
yeah.
I'd put it is this. So the question is, in effect, is could my client be bound by anything that was decided in this? And then is, do I need to attack the judgment on the basis that the judgment is somehow the result of a sham in order to reach the conclusion that I'm not affected by this judgment? So there are two ways in which a judgment could affect a third party. One is if they were party to the judgment itself, and then you get the res judicata effect. But if you're not party to a judgment, the starting point is that you're not bound by that judgment. So in other words, I can't have my rights affected by two people going off and consenting to a judgment somewhere else. Right. There's some obvious public policy reasons for that. That's exactly what we say has happened here. But whether or not it's happened is irrelevant, because all that has happened is there's a judgment between two other parties. The second question is this somehow a judgment in rem? That is a judgment, as they put it, inter omnes. So to be a judgment in rem, it would have to be an order declaring for all of the world who is the owner of the property. And the point is, A, it doesn't purport to do that. It just simply says you shall transfer this to that, these shares to that person. Secondly, it's only the DIFC courts that can declare the in rem ownership of a DIFC company. It's just like real estate. It's the place of incorporation, it's the place of registration, it's the place of existence of that real estate, of that property, where the courts have the jurisdiction to do that sort of thing. So it couldn't be an attempt to say this actually belongs to you. And it doesn't even purport to do that. What it says is you must transfer it A to B. And so implicit in that is that this judgment is not saying this asset belongs to the second defendant. It's just saying you have to transfer it one to the other. So what is the effect of that on my client? Well, it's not an in rem judgment. It can't be bound by an in personam judgment. There's no need to attack it. We're just saying, as between the two of them, she holds it for him. And that comes down to what's in their minds, what they intended when they entered into this agreement and when they effected this transfer. What did they intend to do? Is it really actually that is gone to her for all time? Or is it, as we say, just part of this scheme to try and make him judgment proof? And we say that's the end. So it doesn't involve an attempt to attack a Dubai court judgment at all. It's not inconsistent with a Dubai court judgment. We can't be bound by it under the rules that we apply in this court. And the way that it was presented in the JJC petition, and I've never seen anything like it in my life, I have to say. I was asked a question by the judge. I answered the question. I was then asked another question, and I answered that question. And what the second defendant's lawyers have done is they've presented the first question, they've missed out my answer to that question, missed out the second question, and presented my answer to the second question as if it was my answer to the first. It's quite astonishing. It's totally misleading. Now, I don't make that allegation against Mr. Delefka because he wasn't in, well, his name is not on those proceedings. But this is what you are dealing with in this case. It's unbelievable. So the bottom line then is that on the Lacan point, there's no answer to it. If you do go further and look at this second phase, you've got a claim for enforcement in the DIFC, and then you've got a claim which is a continuation of the claim for enforcement against the first defendant, but simply saying those assets that are in the hands of D2, they need to be brought into the execution of the first judgment because those are DIFC assets under the control of the DIFC courts. There could not be any kind of conflict between that case and anything that went on in the Dubai courts. It would have to be a claim to effectively an anti-suit injunction to block the execution in the DIFC of a DIFC court judgment against DIFC assets. It would be quite extreme, and it's not put in those terms. So that is what I say about the second phase. And unless there's any other questions on the JJC application or set-aside application, I'll leave it there, unless you'd like me to address anything else specifically.
Thank you so much.
Thank you.
I will turn to your opponent now. Well, Mr. Delvica, if I'm pronouncing your name in the right way, I hope. And well, I know your first position that you don't want to participate in the hearing, but I do welcome you strongly. We always welcome people to come and talk to the court and assist the court the way they can. And it's up to you, I think, if you want to reply to what Mr. Smith have said, and if you want to, yeah.
Yes.
Do you hear me? Yeah.
Yes. Can you hear me? That's
yes, I can now. Yes, I can now.
Thank you so much, Your Excellency. Considering the fact that instead of 20 minutes, we've been going through this for more than an hour, may I request a short adjournment for just a few minutes before I start with my submissions?
Okay, why not? Do you want to take 3-4 minutes? Can we, or 5 maximum?
5 minutes max.
Would you be able to finish in 20 or half an hour maximum, Mr. Delfica? Do you think?
I will do my best to finish within an estimate of 20-25 minutes.
Well, that'd be great. Okay, lovely. Thank you.
Thank
See you in 5 minutes then.
Yes, indeed. See you in 5 minutes. Thank you.
Yes, Mr. Delfica.
Thank you, Your Excellency. May it please the court, I appear for the second defendant. I am a practitioner registered with the DIFC Courts Register of Legal Practitioners. My limited rights of audience at DIFC courts are currently and remain provisional, and I thus seek your permission to proceed with submissions on behalf of the second defendant.
You have any objection, Mr. Smith? I'm about to allow him. Yes, please.
I'm grateful. These are the second defendant's submissions in this oral hearing. The second defendant continues to seek the following orders: that the order of Her Excellency Justice Maha Al-Mheri, dated 29th of June 2022, remain in force, that the set-aside application subject matter of this current oral hearing be denied, and that the claimant pays the second defendant's costs incurred as a result of the set-aside application, and the second defendant having to make the de novo application. Unless you'd like me to go into the relevant background, I suppose that we can continue with
Can skip that, yes.
main arguments. Yes, and thank you so much. The second defendant will address the submissions of the claimant generally in the same order. So first we will deal with the matter of the set-aside application itself in form, and then we'll address the matter of the JJC. Now, so pursuant to the set-aside application, the claimant is applying that the order be set aside, that the JJC stay applications be dismissed, and that the courts declare that the freezing orders be maintained. The basis for the set-aside applications was that the order was made without a hearing and without giving the claimant an opportunity to make submissions. That's ground number one. Ground number two was that the order was wrong because the conditions for the stay under the Dubai Decree number 19, i.e. Article 5, are not satisfied. And C, that the stay under the Dubai Decree did not talk about the continuation of the freezing order. Now, with respect to the first ground, that the order was determined on papers, we recall that on 29th of June 2022, the claimant wrote to the registry to inquire about how the JJC stay applications would be determined. The registry replied that the stay applications would be determined on papers without a hearing, and the claimant did not respond to that email.
What date was that? 16th of
29th of June 2022.
24.
Yes, and on the 29th of June 2022, Her Excellency Justice Mahal Mheri issued her order to stay these proceedings pursuant to Article 5 of the decree and the court's case management powers under RDC 4.26.
And what are you saying? Because the claimant chose not to respond to the registry's email and challenge it, so they accepted. Are you taking the D1 position? So by not contesting that email of 25 June 22, they accept that the application should be dealt with in paper.
Yes, this is what we say, that the claimant implicitly agreed and was satisfied that this be the case.
And is this a new position, Mr. Delvica? Like, are you adopting this today, or this is something you maintain from the first date when you have brought the de novo application?
That was
the claimant
our
did.
continuous position, I believe, and
again?
also this is recorded at paragraph 15 that.
Of your de novo application?
No, this is in our submissions made on Tuesday this week.
Oh, I see. Tuesday or yesterday? Last night?
Yesterday, we've submitted the skeleton argument, which is evidently largely
No, I'm talking the position. The position you taking that the claimant.
I'm sorry to interrupt, but I'm afraid the submission is factually false. If you look at paragraph 15, it doesn't make this point at all. It doesn't make this point at all.
I beg your pardon. Paragraph 14, last sentence.
So it simply says claimant is apparent that the claimant was content with the registry's response. It's nowhere said that there is consent. I'll deal with the submission. It's a shame, unfortunately.
Thank you. We did not use the word consent. Now, importantly, if I may, RDC 2369, it does provide that the court may deal with an application without a hearing if, and there were, of course, the three separate conditions. Number 3, subsection 3, being the court does not consider that the hearing would be appropriate. And this is what we say at paragraph 15 of the skeleton argument, that upon reviewing all the documents, Her Excellency Mahal Mheri issued the orders. Therefore, she was evidently satisfied on the basis that of the available documents, i.e. the 4 stay applications and responses thereto, that she was in a position to dispose of the JJC stay application on papers and did not consider the hearing to be appropriate.
Well, that is not our problem exactly, I think, Mr. Delfica, because despite the fact whether the judge see there is enough paper or enough submission, or the application is something can be dealt with paper, that would automatically still give the right for the set aside application. The problem is the only exit I think you have now is to show that the claimant did by any mean agree or blindly agreed or consent that application should be dealt with on paper. If the judge decided it's enough to be dealt with the paper, so her decision will be subject to review automatically. If the parties don't like the result, said the only exit is that she should not decide that is the agreement. If there is an agreement, the claimant only can appeal the decision instead of have it reviewed by another judge at the same stage. You got the point, yeah?
Yes.
Yes.
Well,
and you're saying there is a consent anyway, yeah?
implicitly we consider this to be consent.
Yeah.
Now, then the claimant argues that the order was unjust because the claimant was denied an opportunity to make legal submissions. Whilst the claimant made references to their intimations that they, for example, may wish to make legal submissions, at no point in time did the claimant actually make an application to make legal submissions. Or at no point such an application, if made, was denied. Furthermore, and this is important, when the claimant refers to RDC 410, we know that it is, again, ultimately within the court or the judge's ultimate decision, and not an obligation to provide an opportunity for any party to make representations. Because whilst the claimant is making an emphasis on subsection 2, where the court must specify a time and the manner in which representations might be made, we would like to highlight subsection 1, where it says, after reading the chapeau, where the court proposes to make an order on its own initiative, we would like to emphasize the word may. It may give any person likely to be affected by the order an opportunity to make representation. Therefore, it was within the discretion of the judge, and by judging by the order made on the 29th of June 2022, the judge decided that she does not need to give an opportunity for any further representations.
I see. So it's into you saying this judge discretion to grant or not.
Under RDC 410, yes.
Go on. Yeah.
Thank you. We yet again maintain that the claimant had almost around 2.5 months to make an application to make legal submissions, and again it chose not to, and therefore we say it the claimant did utilize the further responses to respond to the JGC stay applications in the form it considered to be adequate. And again, the order was issued in such circumstances where the judge considered the hearing inappropriate.
Yep.
Thank you. Now, with respect to the factual inaccuracies and irregularities, which is also the basis for the set-aside application, we continue with our position that such oversights were immaterial and could not affect the decision of the order. Now, with regards to the basis that the order doesn't deal with the freezing orders, I understand that there were no submissions made within the skeleton arguments or during this oral hearing. Therefore, it appears that based on this, that the claimant does not appear to be pursuing this ground anymore. Now, as to the JJC stay application being made pursuant to Article 5 of the decree, in 2020, the first defendant's deteriorating financial situation, mainly attributed to the dispute with the claimant, led to the deterioration of the matrimonial relationship of the first defendant and the second defendant. On the 25th November 2021, the second defendant filed for a divorce with the Personal Status Court in Dubai. The divorce was registered under number 916/2021. There was a hearing on the 17th of January 2022 at the Personal Status Court in Dubai. During that hearing, the first defendant and the second defendant managed to reach a settlement before the Personal Status Court of Dubai on the grounds that the second defendant accepted the first defendant's offer to return to the second defendant the shares in the Belgian legal entity, MA Development SRL, and subsequently the second defendant would transfer 66% of the shares in 5 Dining Corporation Limited, that is the DFC company, to their 2 children, Enzo and Santino Mains, i.e. 33% shares each. Furthermore, any income generated by these 2 companies would be utilized towards alimony, maintenance, cost of education for the children, housing allowances, and other standard costs. The Personal Status Court of Dubai issued the divorce order on that basis, and declared the dissolution of the marriage between the first defendant and the second defendant, i.e. all of these proceedings and settlement discussions were held in front of the courts. Furthermore, the divorce certificate number 14/2022 was issued, and accordingly an execution order of 85/2022-204 was issued, ordering the transfer of 66% of the shares in 5 Dining Corporation to the 2 children. Thereafter, on the 10th of February 2022, and you can follow my submissions by looking at the skeleton arguments, paragraph 33 onwards. On the 10th of February 2022, Dubai courts opened an execution file for the settlement order, whereby an order was issued by the DFC to transfer to each of the children 33% of the shares in the DFC company. On the 7th of March 2022, the second defendant filed an enforcement application to enforce the judgment at the DFC court, which was registered. On the 10th of March, the DFC company registrar transferred the shares to the second defendant and the 2 children in accordance with the execution order of Dubai courts. After obtaining the freezing orders against the first defendant and the second defendant, the claimant filed a claim with DFC courts against the first defendant and the second defendant, i.e. these proceedings, seeking the second defendant is joined to the claim for the purposes of seeking a freezing order over the shares held in 5 Dining Company by herself and her children. Importantly, the claimant seeks a declaration that the shares are held on trust for the first defendant. Thus, we say, I apologize. Can you hear me?
I'm having little difficulty now hearing you, Mr. Delfica. I can't hear you well now. Your voice is cut.
Hello? I'm still here.
I think I can hear you, Mr. Dilbecker. I don't know whether you can hear me. I think His Excellency is having trouble hearing you.
Yes, I just got a message of poor network quality.
Oh, okay.
Hopefully
We restore
it will
your picture
resume.
now. Yes, it's better now.
Yes, I apologize.
Yeah, you may continue.
Could I ask where you've lost me?
Well, you were still in the fact of the enforcement of registrar of the companies
Yes.
over the DFC companies.
Okay, thus in these proceedings, the claimant is seeking, amongst others, that a declaration that the DFC courts will make a declaration that the shares are held on trust for the first defendant.
Right. That's the first part of the case.
Yeah, the decree is triggered in circumstances of a conflict as to jurisdiction between DFC courts and Dubai courts. The second defendant submits that by filing its claim at DFC courts, the claimant is presently requesting DFC courts to invalidate a family judgment rendered by Dubai courts and overturn its effects, thus depriving the second defendant, as well as her children, of the rights they lawfully acquired by way of the execution of the settlement and execution orders. In other words, the claimant is requesting DFC courts to exercise jurisdiction over and rule on matters which were already determined by Dubai court. Respectfully, the DFC is a free zone operating within the framework of a common law jurisdiction. DFC courts have no jurisdiction over family or personal status matters concerning any UAE resident. The second defendant and her children are not a party to any and have not been any party to any English court order. Hence, the FC courts have no jurisdiction over the rights granted to the second defendant as a result of the settlement order upon conclusion of the divorce proceedings between the second defendant and the first defendant in the personal status courts of Dubai. Accordingly, on 12th of April 2022, the second defendant appropriately informed the DFC courts of the filing of Dubai courts proceedings against the claimant and the first defendant, and consequently, regarding its JJC application of 7th of April 2022, and sought an order to stay these DFC courts proceedings. Once the JJC application has been filed with and registered by the JJC, all claims, in particular the claimant's claims against the second defendant in the DFC courts, which are subject to the jurisdictional challenge pending before the JJC, it is submitted, must be stayed in accordance with Article 5 of the decree. To avoid unnecessary legal proceedings, the generation of contradictory orders and judgments, and the unnecessary costs for legal representation and court fees that would inevitably result from such proceedings. Moreover, in line with the overriding objective under the RDC pending the decision by the JJC on the JJC application, the DFC court proceedings have to be stayed for the very same reason. It is for the registrar of the JJC to verify whether the conditions of Article 4 of Dubai Decree 19 of 2016, namely the verification of the identity of the parties, the subject matter, the conflicting claims referred, are met, and a case can be then referred to the JJC and registered accordingly. This is what has happened in this matter. Once a case is registered and the JJC assigns a cassation number, it means that the conditions set out in Article 4 are met, and therefore the case is to be considered as referred to the JJC, which can commence the review referral. And here I'm referring to the chapeau of Article 4 of the Dubai Decree 2019, where it says in the relevant part, in the event of a conflict of jurisdiction between Dubai courts and the sentence court, i.e. the DFC court, as none of the court has gave up hearing of the case, or all the courts have given up some or have issued conflicting provisions.
So how the court would give up, you think?
Well, again, by dismissing the claim, by the denying jurisdiction, by
So positive action in the case, yeah?
not necessarily it needs an actual conduct in a case with regards to jurisdiction. We read this provision as saying that if the proceedings in both courts are still ongoing, none of the courts have given up hearing the case. Therefore, this results in a valid referral to the JJC.
I see your point, yes. Yes, unless the court did something to take off the case from its record, otherwise it's an ongoing case.
It is submitted.
And then you saying there is two ongoing cases in two different courts about the same matter, yeah.
Indeed, it is submitted. Reading Article 4 and Article 5 of the decree together can lead only to one logical conclusion. The actual act of a referral, i.e. registration of the matter with the JJC, whilst none of the court has given up hearing the one of the cases, it should automatically result in the stay of proceedings.
Yes, go on.
Thank you. I'm grateful. In this regard, the second defendant's positions should remain the same. These proceedings should remain stayed pursuant to Article 4 and 5 of Dubai Decree 19, 2016. The spirit and the letter of Articles 5 and 6 of the decree are unequivocal. Once an application has been filed with and registered by the JJC, all claims which are subject to the challenge pending before the JJC must be stayed. Again, to avoid unnecessary legal proceedings, contradictory judgments, and most importantly, the cost of legal representations. The overriding objective dictates the same, being that the case is resolved justly, which includes parties being on an equal footing, saving expenses, acting and not only expeditiously, but most importantly, fairly. It is respectfully submitted that the DFC courts cannot create, and I repeat the party's position in this regard, cannot create a binding common law authority interpreting Articles 4 and 5 of the decree, as it is an imperative norm of UAE law, not DFC law, not English law. Without prejudice to the second defendant's primary position, just stated, and for the sake of argument, the claimant asserts that based on DFC court's case law, the fact that competing proceedings have been commenced and application has been made to the JJC by a party does not warrant a stay. Obviously, the stay in these proceedings were not ordered simply based on the existence of Dubai court's proceedings and just filing of the JJC application. It's clear from the order it was issued after Her Excellency Justice Mahal Mheri reviewed 4 separate JJC stay applications, including multiple supporting documents, and on the other hand, the claimant's responses thereto. In these DFC court's proceedings, the claimant is seeking the following. And again, that the DFC court makes a declaration that the shares in the 2 legal entities are held on trust for the first defendant by the second defendant. In Dubai court's proceedings, which the second defendant had to commence, she is asking that she and her children to declare that she and her children are the legitimate owners of the shares in those 2 legal entities, and those shares were lawfully transferred to them as a result of the divorce judgment ordered by the Personal Status Court of Dubai. It is submitted that both proceedings, at their very core, pertain to the same subject matter, the legal and beneficial ownership of the shares in the 2 legal entities. Furthermore, the matter was already decided by Dubai courts once and enforced through DFC courts with respect to DFC legal entity. However, due to the claimant's claim in DFC courts against the second defendant had to return to Dubai courts.
Yeah, may I remind you that if you can finish in 10 minutes, I mean, the reason, I don't want to stop you because I was not alerted you will be delivering oral submission, Mr. Delvika, first of all. And the reason is that in 10 minutes, I gotta go catch up with the Jum'ah prayer. See, I will never confiscate your right. If you can finish in 10 minutes, but if you need more time, I can come back to you after 2 o'clock.
I'm grateful, Your Excellency. I will be finishing in 10 minutes.
Oh, that's great. That's great. Sorry, just to manage my time. Yeah.
Thank you. I'm grateful.
Yes.
Therefore, the claimant submits that there is a conflict of jurisdiction, at the very least, a serious risk of such a conflict of jurisdiction arising between the proceedings in the DFC courts and Dubai courts, should the order be dismissed and the stay of these proceedings be lifted. Moreover, it is submitted, should the DFC courts decide to dismiss the order and lift the stay in these proceedings, in disregard of Articles 4 and 5 of the decree, there is a significant risk of the JJC deciding to discontinue the present DFC court proceedings, thus rendering everything done by DFC courts to date futile. Secondly, that there will be conflicting judgments where Dubai courts may decide to confirm the second defendant's ownership of the shares in these 2 legal entities, and the DFC court determines otherwise on the basis of the claimant's current allegations, which are denied that the second defendant is holding the shares in those 2 companies on trust for the first defendant. For the avoidance of doubt, the second defendant is challenging the DFC court's jurisdiction in these proceedings. The second defendant made its position clear when she acknowledged service of the claim forms. Thereafter, the second defendant made applications for stay based on her JJC application, which are currently being reviewed, and pursuant to which the order was issued staying these proceedings. At the same time, by commencing proceedings in Dubai courts, the second defendant submitted itself to the jurisdiction of Dubai courts. Dubai courts will not be asserting or declaring lack of jurisdiction over the case, unless and until one of the defendants in that case actively challenges jurisdiction of Dubai courts. Moreover, as a matter of practice, Dubai courts, it is submitted, may consider such a challenge in the beginning of a case. But in experience of this firm, it is more likely to leave the determination of such challenges until the end of the proceedings. Thus, whilst the parties wait for an exercise of jurisdiction by a court and or a claim or a disclaimer of jurisdiction, significant amount of time and effort will be exhausted and funds will be spent, likely in vain, which certainly goes against the overriding objective.
Well, I see these difficulties, Mr. Delvica, but what is my position? Like, I do have within my court, within my system, a Court of Appeal binding decision where I used to be a member sitting in that decision. What I might do, like in this, okay, maybe it's as Mr. Mike Smith has said, it's a matter for the appellate level to change this position. Even if you say there are going to be a lot of difficulties, there is unseenable things now, but you go ahead, you make a decision, and then the Dubai Court of JC may reverse all of this all of a sudden, and then there is really problem. But what I'm going to do, I'm bound by Court of Appeal decision. It's binding on me.
It is the second defendant's submission that you may exercise deference by considering the significant differences between the cases decided and the circumstances of this particular case.
Well, that should be something for you to start doing. That's to distinguish this court. I mean, you would invite the court to distinguish the case, and it's another difficult process, whether you can do it at this level or at the appellate level. And the second things, and what kind of submission and support before me now, I mean, assisted by you, supposed to be, in doing the distinguished process.
Indeed. If
Okay.
I may just conclude my submissions.
Yes, please. Yeah.
I'm minded of your time.
Yes, please.
With respect to this hearing, the second defendant submits that the issues raised by the claimant set-aside application continue and remain not to be complex and certainly should have been dealt with on papers only. In these circumstances, the second defendant submits that the claimant requesting an unnecessary joint oral hearing only results in further disproportionate costs being incurred and negatively impacts and exacerbates the financial position of the second defendant and her two children. In conclusion, the second defendant submits that the order appropriately stayed these proceedings pursuant to the clear language of Articles 4 and 5 of the decree, the court's case management powers of RDC 4 to subsection 6, which gives the court power to stay whole or part of the proceedings or judgment until a specific time or event, and for the reasons stated previously and today, respectfully request the court to issue the following orders: that the order remains to be enforced, that the set-aside application is denied, and that the claimant pays the second defendant's costs incurred as a result of the set-aside application and the second defendant's de novo application. Nothing in the skeleton argument should be taken to be a submission to the court's jurisdiction by the second defendant. This concludes the second defendant's submissions. Thank you.
Well, thank you, Mr. Delvic. I'm finishing on time. Mr. Munch Smith, what I know you can. I'm going to allow you to talk about one single point, is about the consent issue.
Yeah,
but not
okay.
the JJC.
So
not the complication, not of the what's of the JJC turnover the events, but only the consent issue.
Understood. Consent. So The point about this is that the email that Mr. Delvaker refers to was sent at 11:54 a.m. on the 29th of June. The order was made at 3 p.m. on the 29th of June. So the submission appears to be that my client consented to a paper determination, after the court had decided that it was going to do a paper determination. So he's saying, oh, well, you consented after the decision had already been made. And then so that doesn't make any sense. And then the second point seems to be that in the 3 hours between being told there's a decision on the papers and the decision actually being issued, that somehow a failure to do something in that 3-hour window gives consent, ex post facto consent, that is consent to something that's already been determined, is nonsense. Obviously, instructions need to be taken, but the point is this, that it's obviously up to the judge. No one is saying that Justice Maha had to have a hearing. No one was saying that Justice Maha had to give an opportunity to make representations. It was within her rights to say, I don't think we need that. But the point is, that's a decision for her. We can't overturn that unless we appeal it. We're not going to do it at that point, obviously. And then if she decides to go down that route, then she's within her rights to do so. But then the rules just provide for the consequences if and when she does so. So unless your Excellency is going to say, well, you know, to preserve the right set aside, the minute that you hear that there's going to be a decision on paper, you need to start firing off unsolicited submissions to the court saying we object to this and it must be overturned. Unless you take that position, which is inconsistent with the rules and makes no sense, then this point goes nowhere.
Okay.
I mean,
well, I know it. Yeah, I have taken note of your defense at this point, Mr. Smith, and I unfortunately I think this should conclude our hearing today.
Thank you.
I will reserve for judgment. You will have my judgment very soon. It's as coming Monday.
Thank you very much.
Before 4 p.m.
In relation to the costs, obviously we haven't dealt with those. Can I suggest that those are dealt with on paper? And for these purposes, my client's prepared to consent to a determination on paper. And if Mr. Derfker also consents, we don't have the first defendant, obviously, but it seems to make sense that the parties should exchange short submissions on costs once we get your judgment. There may be a short delay for availability because I'll be away, I think, for 3 weeks. It may be if you absolutely want that to be determined faster, we can have other members of the team make those cost submissions, but I won't be available to do it until I think the 25th of August or something like that, 22nd, or whenever it is that I get back. So I would ask Your Excellency.
I don't think we are in a super hurry, like with the cost order, but
yes.
we just need to look at the order on the merit.
On the order on the merits, then if Your Excellency could just direct cost.
Yeah, I would.
I'm very grateful. Thank you.
Thank you very much.
Thank you for your
time. For your appearance today. Thank you for your submission. All the best. Have a good day ahead, all.
You too.